Please be seated. We'll hear argument in 2270, Preston versus M1 Support Services.
May it please the court, Mr. Vladeck will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court, good morning. As this court recognized in K-9, there are exactly 2 ways in which a civil suit against a private military contractor can raise a non-justiciable political question. Either the plaintiff's claims themselves require courts to second-guess non-reviewable military decisions, or the defendant's defenses will require courts to do so. This case presents neither of those scenarios. The petitioner's core claim that M1's maintenance and inspection of the crash helicopter failed to comply with the Navy's explicit contractual requirements implicates no military decisions, let alone non-reviewable ones.
So let me ask you, is the complaint that the procedures were inadequate or that they were bad, or that there was a failure to comply with those procedures?
Exactly the latter, Justice Lehrmann. And if I might refer your honors to tab A of our oral argument exhibits, we cite 2 various examples in the record that supports that part of our claim. For example, we cite to the testimony from the M1 technician, Mr. Mulak, at SR 266-68, who testified that he did not understand the dangers associated with wire bundles resting against fuel lines. We have the testimony from the M1 collateral duty inspector, Mr. Kirby, who testifies that he believed electrical wires were permitted to rest directly against cabin fuel lines. And we have the testimony from M1's own site supervisor, Mr. Metler, who testifies that M1 had a contractual duty to inspect all fuel lines for, quote, leaking, chafing, obvious damage and security. So, Justice Lehrmann, I think the core of the plaintiff's complaint is that the contractual duty was clear and it was not followed. And that is perhaps the single most important respect in which this case differs from K-9. Not the only one, but the one that I think absolves this court of the need to answer any harder questions. Because at its core, we prevail if we can show at trial that M1's failure to comply with these requirements was a significant factor in causing the crash.
So your argument about that the doctrine is limited to war zones really doesn't matter.
So, indeed, if I might, Justice Lehrmann, I mean, to go back to this court's decision in K-9, the point, Your Honors, is not that the war zone is an on-off switch. If Your Honors might refer to our chart in tab B of our oral argument exhibits, you'll see that there are cases in war zones where courts have rejected the political question doctrine. But what this court said in K-9 is instructive. What this court said in K-9 was that there are issues unique to the battlefield. That is to say, there are military decisions, Justice Lehrmann, that will be far more susceptible to judicial review in ordinary circumstances, away from battlefields, than the Army's decisions in K-9. So it's not, Your Honor, that the battlefield's an on-off switch. It's that the battlefield locus dramatically increases the possibility that the court's review will require it to second-guess unreviewable military decisions, not just military decisions. And that's what gets to the second part of our claim. The second part of our claim is that M1's defenses also do not require this court to review non-reviewable military decisions. First, that's because review of the Navy's role would not require this court or the trial court to second-guess the kinds of military judgments that courts have previously held to be non-reviewable. And second, and in any event, the jury cannot allocate fault to the Navy as a matter of law under settled maritime principles of joint and several liability. So there are 3 different grounds, independent grounds, each of which conclusively distinguish this case from K-9, any one of which is sufficient to reject applicability of the political question doctrine, all 3 of which together, Justice Lehrmann, to us, make this a relatively easy case.
Assuming we agree, is there any room left at all for a government contractor defense on the merits?
I believe there is, Justice Boyd, and that's what we'll have to fight over at trial. So just to remind Your Honors of where we are in the posture, we had just about finished fact discovery. We had not gotten past that point. when this court's decision in K9 was handed down, when the respondents filed a plea to jurisdiction. There's still, Justice Boyd, a little more discovery that I think would have to go forward. And we have never denied that the respondents are entitled to raise a Boyle defense, the government-contractor defense. The key there is going to be whether the respondents can show that, to quote Justice Scalia's opinion in Boyle, the state-imposed duty of care, that's say the tort theory under which we're seeking to recover, which actually here is a federal theory, that is the asserted basis of the contractor's liability, is precisely contrary, Justice Boyd, to the duty imposed by the government contract. We don't think they can show that, but they are allowed to try to show that. We haven't gotten that far yet. And to go back to Justice Lehrmann's question.
Is there a motion for summary judgment?
There was a motion for summary judgment pending.
So what discovery, was there some dispute about that discovery hadn't finished?
So there's the potential for a dispute between, I believe, metallurgical experts, Justice Bland. We hadn't gotten that far. And I think the question that was before the trial court in the motion for summary judgment was whether there was a triable issue of material fact on which the experts could reasonably disagree. But if I might, Justice Bland, that goes to that goes to whether we can show that the failure of M1 to conduct the inspection it was required to inspect was a substantial factor in causing the underlying accident. It doesn't go to the justiciability issue at all. Right? That is to say, the dispute that we are expecting between our experts and theirs is simply about whether we have carried our burden to show that we have a claim for 3 of the plaintiffs under the Death on the High Seas Act, for the 4th under federal common law maritime principles.
I'm trying to think through the relationship between the political question doctrine and the Boyle government contractor defense. Are you familiar with any cases that involve a contractor working with specs and that potentially could implicate Boyle where the political question doctrine has been applied?
Where it has been applied. So I think the closest I can think of, Justice Busby, is the Harris case. The Third Circuit case, this was the one about the improperly grounded shower in the forward barracks in the combat zone. And, Justice Busby, I think there could very well have been a dispute on remand. Indeed, I think the Third Circuit contemplated that there would be a dispute on remand about whether, even if the political question doctrine did not apply, there would be a viable contractor defense. And if I might take that one step further, I think what that illustrates, Your Honors, is one of the fairly basic sources of disagreement between us and M1 on how to frame the issue. The plenary control prong of the political question doctrine is, Justice Busby, I think, getting at those cases. That is to say, cases where the underlying claim is not that the contractor was on a frolic or detour, but that the contractor was simply doing what they were ordered to do by the government. And Justice Busby, it's in those cases where I think you could have both issues. Because it's in those cases where I think a contractor might have a political question defense if the underlying military judgment is itself non-reviewable. But if the underlying judgment is reviewable, Boyle might still provide a defense, insofar as the contractor was simply carrying out the contract instructions, insofar as the contractor was just following its contractual duty.
Is the Navy's judgment in this case reviewable in, for example, I think they assert that the Navy itself carried out one of these phase maintenances and used the same M12 card. And the Navy was aware of a flag from an earlier contractor, L3. And then, obviously, there's the whole quality assurance process that the Navy does. And would any of those constitute non-reviewable military decisions?
So we don't believe so, Justice Bland. I mean, we believe that even if there were clearer evidence in the record, and to be clear, there isn't, that this was much more the Navy's responsibility, that's only the first step of the analysis, Justice Bland. There's still the question of why those decisions by the Navy would implicate the kinds of sensitive judgments that are not usually reviewable by the courts. And in this case, we don't believe they do because these are ordinary maintenance decisions. In contrast to K9, where again, to go back to what this court said in K9, the issue was that the Army was not following its own guidance, Justice Bland, perhaps because of the battlefield setting. That it wasn't just that the Army was negligent, it was that the Army's negligence could have been explained by what this court called, quote, unreviewable decisions relating to housing and maintenance on the battlefield. And that's at
But
page
it wouldn't make any difference whether this particular accident occurred over water or on the battlefield, would it?
So, Mr. Chief Justice, I think it would, and I think the McMahon case from the 11th Circuit is a very good example of that. McMahon is an aircraft accident in Afghanistan, in a forward combat zone, where the 11th Circuit, applying all of these same considerations, held that the political question doctrine did not apply. In other words, right, the battlefield locus, to go back to Justice Bland's question, increases the possibility that the underlying military decisions will be non-reviewable, but not conclusively so. Right? That, again, the question is, what are we actually asking about what the Navy chose to do? And with respect, in reading my friend's briefs on the other side, I didn't see specific examples of decisions where there are examples of how courts have previously said those decisions are not reviewable. And that's the burden as the party moving on the plea to jurisdiction that M1 failed to carry. And if I might step back from that for a second, again, even if there is some room for doubt on that point, we come back to the fact that this is a maritime case. And we come back to the fact that unlike in K9, when the Army was going to be on the verdict form, when there was no question that the Army's responsibility was going to be an important part of the court's analysis, that's not true here. Because under these principles of maritime law, the courts are applying joint and several liability, the Navy's responsibility is irrelevant so long as we can demonstrate that M1 was a substantial factor in the accident.
What about McDermott and U.S. versus reliable transfer and those cases that apply proportionate responsibility concepts to maritime cases?
So, Justice Bland, you're absolutely right that they do, but they do it only in the context of settling defendants and non-immune defendants. And what I think that the brief on the other side misses about those cases is that in that context, the only thing that's happening, Justice Bland, is the pie out of 100% is being divvied up based on who settled. That is to say that the joint and several liability principle is just tweaked a little to account for settlement credits. As McDermott itself says, that's only for non-immune defendants. Here, the Navy is immune, not because of non-justiciability, Justice Bland, but because of the Ferris Doctrine. And that's why the Navy can't be on the verdict form in this case. That's why there's no scenario in which, even if the Navy's decisions were unreviewable, and we don't think they are, those decisions would actually have to be scrutinized to reach the underlying gravamen of our complaint, which is whether we have a claim under the Death on the High Seas Act and under general principles of federal maritime law for M1's negligence.
Was there even a claim in the parallel federal proceeding against the other defendants that that suit was barred by the political question doctrine?
There was not, Justice Busby, and this goes to one last point I'd like to make before yielding to my colleague. There are all these cases out there. We cite to them. We cite to the DeVries case from the U.S. Supreme Court in 2019, where it was the Navy that installed asbestos on parts manufactured by Air Liquid Systems Corps. There's Boyle itself, where it was the Navy who asked for the modification to the helicopter that ultimately contributed to the fact that the crash was fatal. There's this court's decision in Torrington Company versus Stutzman, where the issue was that the Navy had mishandled bearings in an aircraft that led to a crash. And Justice Busby, the political question doctrine is nowhere to be found in any of those cases. That's not because the parties forgot to raise it. It's not because Justice Scalia didn't think to bring it up. It's because the political question doctrine is and has always been a limited exception that does not insulate all military judgments from judicial review, but only those that require courts to second guess especially sensitive military decisions. Again, to quote this court in K9, the political question doctrine is not always easy to apply, but it certainly cannot be invoked to bar all claims that merely happen to have a military setting. And the lower courts in this case, I think, failed to abide by that understanding of the political question doctrine. Again, if your honors refer to the chart in tab B of our oral argument exhibits, you'll see the parties between them across 9 briefs in this court have cited 14 cases where courts have specifically discussed application of the political question doctrine to private military contractors. Justice Busby, only 5 of them actually held that the doctrine applied. And all 5 were combat situations in Iraq and Afghanistan. Again, that's not conclusive. We do not dispute that you could construct a hypothetical. There's the Tiffany and Aktepe cases against the United States themselves, which were political questions off the battlefield. But of course, Tiffany was an air-to-air interception of an unidentified aircraft in an air defense identification zone. Aktepe was live-fire missiles hitting a Turkish destroyer during an exercise. Those cases, Your Honors, are the exception that prove the rule. And the rule is that the political question doctrine is limited, that if the contractors in this case have a defense, it's Boyle, and that's what the trial court should be allowed to consider on remand.
Any other questions? Thank you, Mr. Vladeck.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Whitty will present argument for the respondent.
Mr. Chief Justice, may it please the court. The District Court and the Second Court of Appeals correctly determined that this court's opinion in American Canine versus Freeman mandated the dismissal of the action under the political question doctrine for lack of subject matter jurisdiction. For if the political question doctrine applies to a case in which the military's decision-making is placed into question with regard to the training and kenneling of dogs, surely it must be applied to a case involving military decisions regarding the maintenance of combat helicopters and the training of their crews.
Can you explain why that would be the case?
It'd be the case, Your Honor, because in an action involving the training and equipping of the military and its personnel, inherently those kind of judgments are going to be brought into effect. In fact, the Gilligan versus Morgan case says, categorically that the professional decisions related to the composition, training, and equipping and control of the military forces are essentially professional military judgments.
But K-9 did not deal with the maintenance of the kennel or the wall or anything like that. This does. This has to do with maintenance of the helicopter and whether or not that the procedures that the military had set forth were complied with, which is different than K-9. So why would that doctrine apply here when we're talking about maintenance or complying with the requirements that are set forth?
Well, with respect, Your Honor, that is only looking at the plaintiff's particular theory of this case and what they say was the cause of the accident. M1 has raised the defense, which states that it was primarily the Navy's responsibility in its decisions, its failure to specifically require the inspection of the wiring bundles, the continued use of the Kapton wiring bundles when it was aware that it was problematic for use on this kind of aircraft, and even the decision at a high level to continue to use the Sea Dragon helicopters when manufacturing had ceased and spare parts were no longer available for this aircraft. Taking a look at the dispute as a whole, and not just the plaintiff's theory of the case, it was evident that those kind of decision-making would be in question in the case. In fact...
And is that only because you can assume, and I understand you disagree that the Navy can't be on the verdict form, but assume that we decide under maritime law that they can't be listed on the verdict form. I assume you would still have a sole cause defense, but we said in K-9 that that's not enough to trigger the political question doctrine. So what sensitive Navy decisions are being implicated if they can't be on the verdict form?
Well, Your Honor, I would disagree that...
I understand.
Well, even in the reading of K-9, certainly this court cited the Harris opinion and stated the Harris holding. I do not read this court's opinion in K-9 as necessarily adopting any kind of rule that says when sole cause is the nature of the defense, that the political question doctrine is not implicated. In fact, I don't think that works because when we're evaluating causation, we're necessarily evaluating not only philosophical causation in the sense that every act can be traced back to the Big Bang, but we're also evaluating responsibility. We don't generally say that something is the cause of a mishap or an accident or a misfortune unless there is some kind of fault or responsibility which is placed upon the causal actor, whether or not that causal actor's responsibility is going to be placed on the verdict form. So, it's our position that sole cause does trigger the political question doctrine.
But what's left of Boyle under your reading? It seems like if you've got a case where there are specs and the question is whether it's followed, that the contractor is always going to say, well, there's some other cause here, and point the finger back at the Navy or whichever branch you're dealing with, and then you never ever get to Boyle because the cases just go away under the political question doctrine.
Well, I believe that Boyle would still exist in cases where the contractor, well, there's no question about the appropriateness of the specifications, for example, would be one of those examples. I think that there could be other instances. But of course, the problem is that Boyle and the government contractor defense is just a substantive defense, whereas the political question doctrine goes to the jurisdiction of the courts.
But they seem to be animated by the same concerns if you read the decision in Boyle.
In part, they are, Your Honor. In its description of the political question doctrine in Torrington versus Stutzman, this court said that the primary motivation of the government contractor defense is basically guarding the public funds, because without the government contractor defense, then contractors would have to insist on all kinds of indemnity provisions and things like that in the contract, and would raise the costs to the military and to the government in those situations. So that's the primary purpose of the government contractor defense. Boyle does talk about one of the other advantages is that it tends to avoid the sort of collisions between the political branches that would otherwise occur without it. But the political question doctrine, that is its primary. In fact, it's virtually its only justification is to keep the judiciary from stepping into those roles where it would be evaluating military decisions that it's not competent to evaluate.
You say that, it seems like that would be awfully broad, though. I mean, if we had a case about say the Department of Public Safety equipping state troopers with improper equipment for budgetary reasons, it seems like the same political question doctrine issue would come up in that case if it's that broad that we're not supposed to intrude on the budgeting priorities of other branches. And I haven't ever heard of the political question doctrine being applied to an issue like that.
Well, I haven't either, Your Honor. I don't think that it's been sought to have been applied outside of the military context, except for, of course, completely different true political questions, like the gerrymandering case that was before the Supreme Court a couple of years ago. But that raises an entirely different set of issues. I think there's a recognition that military decisions, rather than just civilian budgetary prioritization decisions, create an entirely new set of considerations the courts simply aren't well constructed or well equipped to deal with.
Along those lines, in American Canine, one of the examples of a judicially manageable without interference in the other branches kind of case is a typical tort case. What makes this case different from a typical maritime tort case that would make it or render it judicially unmanageable and subject to interfering with the other two branches?
I think that a good comparison might be with the Presidential Airlines versus McMahon case, which my friend cited to. That was a Simon Pure aviation accident, and it even occurred in a war zone, occurred in Afghanistan. But the charter airline company flew the plane into a mountain. There was no contention that the flight should not have been operating because it was unsafe. The accident had nothing to do with enemy action. It was simply a navigational error. And then the Army's decisions were not called into question in the case. So that was the sort of case where, although it's in a military setting, there was no reason to apply the political question doctrine.
But what's to prevent the defendant in a case like that from pleading some defense or third-party allegation or sole cause argument that, as I understand your position, automatically triggers the political question doctrine and requires dismissal?
Well, to be clear, Your Honor, pleading alone would not trigger the political question doctrine and mandate dismissal. The trial court still has to act as a gatekeeper and still has to have a record before it, as this district court did.
Well, but the court didn't rule on the motions to designate responsible third parties, so aren't we getting the court before the horse? If we're trying to decide if there are defenses here that are going to require reexamination of sensitive military decisions if we don't even know who the responsible third parties are going to be?
Well, of course, that assumes that they would have their fault, the military's fault would have to be determined on the blank, and they would actually have to formally be
Right. Well, it seems
be
like
the
to
designee.
put the military on the blank, you would both have to have the court rule on your motion to designate them as a responsible third party and then rule on this issue about whether maritime law allows it. But I think you also move for leave to designate the settling parties as responsible third parties. And I may be correct that the record's silent on whether that's been granted or not?
I believe that that is correct, Your Honor.
Okay,
Um,
so
that-
can we really now evaluate how this case is going to be tried and whether it's going to implicate sensitive military decisions if we don't know who all the responsible third parties are going to be?
Well, Your Honor, I think that first of all, there's no objection to the settling defendants from the Connecticut suit.
I think they said no procedural objection.
There was no procedural objection even to the Navy.
Right.
But
there's a substantive
there's no
objection.
substantive objection to the Navy's, but not to the Connecticut defendants' role in the case. So I think that we can assume that they're going to be part of the case and that there will have to be a determination made of their relative responsibility.
But there's not been a motion to designate the crew members, is that right, as responsible third parties?
Well, they would be first parties, Your Honor. There is a contributory negligence plea. And so their responsibility, assuming that evidence is produced, would be assessed by the trier of fact. And that, of course, is another way that the political question doctrine could enter the case. Because, as we know from Taylor and some other cases, that contributory negligence is another means by which those issues are introduced.
So I think what I understood you to say a little earlier then is that under your approach to the political question doctrine, the trial court is permitted to exercise jurisdiction to allow for discovery and motion practice until the record gets to the point where the trial court can then decide, no, sorry, this is going to run afoul of the political question doctrine, and now I no longer have jurisdiction.
Yes, Your Honor, that's correct. The court has authority to make fact findings related to its jurisdiction in this regard, and the district court did here, made a whole series of findings of fact and conclusions of law.
Is that proper if there are disputed facts?
Yes, Your Honor, it's very proper. This is not a case where the summary judgment standard of Miranda would apply to a determination of jurisdiction, because the jurisdictional factual questions are not intertwined with the decisions that the trier of fact is going to have to make on the merits.
How not? If the question is whether somebody whether some other parties could potentially be negligent, it seems like that would also be a merits issue.
Well, you use the word potentially, and I think that's the key to the whole thing. All that the district court had to determine is the Navy's decision-making being questioned in the case, and is there grounds for doing so? Is there an evidentiary basis for that? It doesn't have to resolve the question of whether the Navy is in fact at fault in any way, or is in fact causally responsible in any way for the accident, only just whether the facts that have been developed indicate that that could be a question in the case. And I don't think that there's any dispute, even from petitioners in this case, that the Navy's decision-making could legitimately be questioned in the case. They only take the position that it would be a non-reviewable sort of decision-making, and that's the contention with which we have a very strong objection, because we think that categorically a decision relating to the equipping and training of the military forces are, under Gilligan, unreviewable. And for that reason, the district courts and the Court of Appeals determinations were not only justified, but were mandatory under the existing law.
So the federal court in Connecticut should have dismissed this case under the political question doctrine, and Torrington and several of the other examples that were given should have been dismissed under the political question doctrine.
Well, we don't know what contentions were made against those particular defendants in Connecticut and what their defenses were, and to the extent to which their defenses raised the issues of the Navy's responsibility. There are scenarios where, arguably it should have been dismissed, but we don't have that record in front of us to make that determination.
How do you distinguish the Lofgren case?
The Lofgren case in the Middle District of Tennessee, that was the ATV case. It involved training of a West Point cadet on a fort in Tennessee. The trails that were normally used for that activity had been closed, and they decided to have the cadet use the sniper range instead. There was an accident, and the cadet was harmed.
The seats broke, and there was allegations that the cadet that was driving too fast, and the instructor had asked him to slow down. And so in that ball of facts, isn't there some sort of attribution of fault to the military? But ultimately, the district court concluded that the seats breaking was the consequential factor that led to the lawsuit, and that the decisions of the military, while they might be implicated, were not sensitive, unreviewable decisions. And why would you say that these are, or that maybe the ones in Lofgren were?
Well, fundamentally, we think that the judge in Lofgren called the balls and strikes wrong in determining that he had a reviewable decision in front of them. We think that the decision on how you train a person in the use of the ATV, and whether or not you might place him in a less safe or less usual environment for that kind of training, that's directly the kind of military judgment that we don't think are reviewable by the courts, and that really the Lofgren judge should have taken that into a greater degree of account. But certainly it is not, there's no indication for the Lofgren case that there was any decision of the sensitivity that is involved here with regard to, for example, whether the Sea Dragon helicopter should even have been used under the circumstances in which it was being used, given its maintenance issue, whether or not that there should have been substantial mechanical repairs done to the helicopter and replacing its Kapton wiring before it was placed into operation. Those were much higher level decisions than were placed into question in Lofgren. But primarily, we think that Lofgren is just decided wrongly because the decisions that were there in Lofgren should have been placed on the unreviewable side of the ledger. I think that a very important issue for the court to determine in a case like this is exactly what is the standard of review. As indicated, we don't think that what we're looking at is the question of whether there was a fact issue raised as to, for example, plenary control, or whether there was a fact issue raised with respect to whether military decisions would be implicated. Those are not questions which go to the merits of the case, and therefore were clearly within the ambit of the district court to determine. And under this court's opinion in Vernco Construction, and as explained by the Court of Appeals in the Poindexter decision, those determinations should be made on a factual and legal sufficiency basis. And of course here we're only concerned with legal sufficiency. And there has never been any kind of challenge of the findings of fact and conclusions of law based on either factual sufficiency or legal sufficiency. So in a very real sense, the arguments that have been being made here today have already been forfeited by the petitioners.
Unless we conclude that those fact issues overlap the merits and therefore they were improper for findings, right?
That's correct, Your Honor. And it would be interesting to know why it was the petitioners who asked for findings of fact and conclusions of law after they received the court's order. Presumably, at least at that stage, they believed that they had to challenge the sufficiency of those findings, rather than just go up on a summary judgment record and show the court an issue of fact. And if you look especially at the plenary control issue, I think that the evidence is very ample as a matter of fact that the Navy had very extensive control over the contractual regime.
And that's going to be an issue under the Boyle defense at trial, so it seems like that would overlap the merits.
It's partially overlaps the Boyle defense in the sense that both are looking at the degree of specificity of the specifications. Now, you know, there is always going to be some overlap. I see my time is up, if I may be allowed to finish the question. There's always going to be some overlap in the sense that when you're identifying what the issues are which implicate the military judgments in a political question doctrine case, you're going to have to make some kind of factual determinations which have some similarity with factual determinations you're going to be making on the merits. But the ultimate factual question, the question that's answered by the jury or the judge, is not the same as the questions that are answered when we're trying to make a political question doctrine determination.
Any other questions? Thank you, Mr. Whitty. Mr. Vladeck, I believe you have 5 minutes.
Thank you very much, Mr. Chief Justice. May it please the court. I'd actually like to start with the Gilligan case because I believe that was the only case I heard my colleague refer to, Your Honors, that actually supports the proposition that military decisions regarding training and equipping are per se unreviewable. Your Honors, Gilligan, if you read it carefully, says far more than that. Gilligan was after the Kent State Massacre, and the relief the plaintiff sought was an injunction subjecting the entire Ohio National Guard to the continuing supervision of the federal district court in every aspect of its daily operations. I don't think it's hard to imagine why the Supreme Court in that case thought that was a bridge too far. Chief Justice Berger's opinion is replete with explanations of how the type of relief the plaintiffs were seeking is what made that dispute non-justiciable. And just 10 months later, Your Honors, a damages case arising out of the same incident, the Kent State shooting, went forward to the Supreme Court. Scheuer versus Rhodes in 1974 was the same facts, it was the same claims, it was a damages case. No one suggested it was non-justiciable. We think that that's consistent with what the Supreme Court, the U.S. Supreme Court said in Zivotofsky, that the political question doctrine is a narrow exception to the general rule of justiciability. And with regard to the arguments you heard from opposing counsel, I think the word potential was doing a heck of a lot of work in his responses to both Justice Boyd and Justice Busby. Yes, it is possible that things will arise on remand that could change the dynamics of this case. But that's not where we are. Where we are right now is with the plaintiffs having pled claims that do not require the trial court to second-guess any decisions by the Navy. There has been no assertion of defenses yet by the, there's been a Boyle defense, but that, of course, does not implicate non-reviewable decisions by the Navy. My colleague mentioned the McMahon case about the aircraft accident in Afghanistan, and he suggested that was not a political question because there was no contention in that case that there had been negligent decisions by the military. Well, of course, under the rule that my friend is arguing for, those contentions will become part and parcel of every single motion contractors file in any of these cases going forward. That is the problem here, that this case really is the fulcrum for how far K-9 is to be understood. In reality, military decisions are reviewed by Texas state courts and by federal courts all the time. The Federal Tort Claims Act was enacted in 1946 in part in response to military vehicle accidents during World War II. The whole point of the regime was to subject the federal government to more tort liability for what my colleague calls military decisions. Boyle itself would make no sense under the approach to the political question doctrine outlined by the respondents. Maritime law, as in the DeVries case, would make no sense if you could never have a claim involving military vessels. And that's where I come back to K-9. And I think the most important point I'd like to leave your honors with is exactly how this court has an opportunity in this case to clarify exactly what K-9 got right and exactly how far it should go. K-9 was a battlefield context K-9 asked this court to revisit sensitive decisions the Army made in a context in which there were reasons why those judgments were not guided by ordinary tort principles and should not have been subject to judicial review. And even then, Your Honors, this court was at pains to stress that the political question doctrine does not apply anytime there's a military issue somewhere in the case, to reaffirm the Zivotofsky principle that this is a narrow exception, and if I might, to quote then Judge Kavanaugh from the D.C. Circuit in 2010, to reaffirm that the political question doctrine has occupied a more limited place in the U.S. Supreme Court's jurisprudence than is sometimes assumed. This case is a simple, ordinary tort case about contractual violations by a maintenance contractor. To dismiss it based on the non-involvement of the Navy, to dismiss it in a context in which the Navy cannot be held liable, and in which the Navy's liability is not relevant to the respondent's liability, is to take the narrow decision in K-9 and convert it into the rule. And it seems to me that, in fact, this case presents a perfect opportunity for this court to do exactly the opposite, and for this court to not make this the sixth case ever where a private military contractor has successfully defended an ordinary tort suit because of the political question doctrine.
Any other questions? Thank you, Mr. Vladeck. Case is submitted. That concludes the argument set for this morning, and the marshal will adjourn the court.
All rise. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.